day in and day out, I believe that even on the social media and especially in the newspapers, etc., including the debates, an issue which is commonly discussed about is Constitution of India. The rights within the framework of the Constitution of India, the fundamental rights and duties, they all arise out of the principles and acts and rules as laid down in the Constitution of India. We all believe that the writs we commonly read about in the newspapers or on the press, that a writ was filed seeking a writ of mandamus, certiorari, prohibition, habeas corpus. Similarly, we talk about fundamental rights, right to speech, etc. They all emanate primarily from the writs being filed under Article 226 or the revisional jurisdiction under 227. And thereafter, we also speak about the powers under 32. And there's always a debate as to whether which has more vast powers under Article 32 or 226, and what are the superintendents of power. But that primarily would not be the debate as such, but the compass of scope within the means of Articles 32, 226, and 227 of the Constitution of India is a topic which we discuss not only as a students of law, a common man in the judicial setup as such. Keeping in view the growing discussions and debates, we thought, why not take a topic which even a common man wishes to understand, especially the terms of review and scopes within that. Consequently, we requested Mr. Mohan Katarki, a senior advocate in Supreme Court of India, who is a well-known name. His contribution towards the evolution of the constitutional law, more so in the dams, rivers, etc., is known to everyone. And he was kind enough to share his knowledge when we requested him that kindly share the knowledge. He accepted that, and as such, he's on our platform. Without taking much time, I would request sir to take things forward. Over to you, and thank you, sir, and to all the participants. We welcome you all. And again, what we say, kindly maintain social distancing and wear the mask, which is an important thing which is emanated with the flux of time, especially after this COVID-19. Over to you, sir.
Thank you, Vikas. May I, at the outset, thank you again for inviting me to speak on this occasion. Initially, I was hesitant to speak on a topic which looked simple, because I said, am I going to speak in the law school to teach the students, or are we going to address the lawyers? If you're addressing the lawyers, naturally we presume that we are going to speak from an angle which might be a proposition which they agree or do not agree. Therefore, after much discussion, we decided to phrase the proposition like this: the changing compass of judicial review under Articles 32, 226 and 227 of the Constitution of India. You all been familiar with judicial control over the actions of the state. The term judicial review is a term of art. It signifies the control of the judiciary over the administrative actions of the executive and the legislative actions of the legislature. It ranges, in fact, from administrative action and goes up to the constituted power exercised by the legislature. As you are all aware, in India, the Supreme Court or the High Court can strike down even the constitutional amendment made under Article 368 of the Constitution if the court comes to a conclusion that it violates the basic structure, which is the implied limitation conceived by the court judicially under Article 368 of the Constitution. Therefore, there has been a lot of debate around the world. In fact, very intensely debated in the United States of America, where they don't only have judicial review or the administrative action like in England, also over the legislative actions as in India. So what is the foundation? What is the philosophical foundation of this judicial review? Why should the legislature, why should the administrative organ of the government be subjected to final say of the judiciary? Should not the legislature, should not the executive left free to decide for itself? After all, they also act in public interest. Many have seen this as undemocratic, that some judges sitting in the ivory tower who are not answerable to public, as the ministers are answerable to the public through the legislature, they decide over important policy matters in the name of legality. So the questions are being often asked and very intensely debated around the world, particularly in the Western world and in the United States of America, that what is the juristic basis and what is the basis for this judicial review? How do you reconcile this power of judicial review with the people's power in the democracy? The jurist-centric argument in support of judicial review emanated in England in order to uphold a rule of law. The government, after the advent of social contract theory, was conceived as the government by rule of law, not rule by law. When rule of law became necessary, it became necessary for the vesting of power in the judiciary to control the administrative actions. In United States of America, though they inherited the same process, but when it came to the judicial review of legislative action, in Madison case, it was logically deduced as a juristic argument to conclude that the courts have the power. But this is a legal deduction. It still doesn't answer the main question: why should courts be granted such a power? The argument which has been advanced in the couple of decades is judicial power is necessary as a counter-majoritarian instrument to control the government which acts on majority in the legislature. It sounds great, because today in the written constitution, you not only find the powers of the government, you also find certain areas, certain spaces which are reserved for the individuals, namely the fundamental rights or basic rights, over which the government has no authority to interfere. They cannot act, which amounts to interfering in these areas or trampling into these rights. So if these are the important things, the basic rights and fundamental rights, then they can't be paper rights. They have to be enforceable rights. If they are enforceable rights, then the conferment of power in the hands of judiciary as an external body, as an independent body, manned by professional judges who do not answer to any political wings or who have no stakes in the political outcome in the nation, should be trusted. They should be vested with the powers. So that's how the judicial review has been justified in the constitutional setup, particularly the written constitution. No doubt, the criticism continues to exist. You often hear judicial outreach. You often hear the executive voice being muzzled by the judiciary. You also hear the courts dictate the policies, courts make the law. These are all the arguments being made, despite it is a settled proposition now that judicial review is a part of constitutionalism. There cannot be a written constitution in the modern sense without the courts being vested with power to review both administrative and legislative actions. Even in England, where the parliament is not amenable to the writ jurisdiction of the English courts, there has been very strong debate that they are indeed amenable. They go back to the old Bonham case, when the court said, if the law made by the parliament is inconsistent with the reason and the common law, such a law the judiciary will not enforce. Because the argument is, who said the parliament is supreme? It's the judiciary. If judiciary had said the parliament is supreme in England, the judiciary can say, yes, it is supreme, but subject to these riders. In fact, this is how the Supreme Court in the United States of America came to the conclusion that it has the judicial power to rule on the constitutionality of the law made by the legislature. The US Constitution also doesn't expressly recognize the power in the judiciary to rule against the validity of the law passed by the legislature. But it was recognized step by step as a logical conclusion. In one of the articles published in the Cardozo Law Journal, very interesting deduction is made how the American Supreme Court finally came to the conclusion that it has such a power called judicial review power. The first thing is, it is the duty of the judiciary to apply the law. This is the first principle which the American Supreme Court stated. Who applies the law? It is the judiciary. Once the judicial branch is created under the Constitution, the duty of the judiciary is to apply the law. There is an acceptance of a proposition that the power to apply the law vests with the judiciary. The second premise is, when there are two contradictory laws, the application of one of them excludes that of the latter. When two laws are contradictory, it is logical for the court to decide which prevails over the which law. So one law will have priority and court will enforce only one law if there is a conflict. Then the third premise was, the Constitution is the supreme law. The Constitution is the supreme law and the defining criterion of legality for other norms. The written Constitution in America, United States of America, is a supreme law. So as in any country now where it is governed by the written Constitution. So once you accept the Constitution as the supreme law, in a Kelsonian language, that is Hans Kelsen, who called it a grand norm in the hierarchy of norms, the highest norm in the Constitution. So the constitutional law or the Constitution is the supreme law of the land. That is the principle on which the US Supreme Court proceeded. Then the fourth premise was, the supremacy of the Constitution implies that when it is in conflict with the norm enacted by the legislature, when it is in conflict with the act passed by the legislature, the latter ceases to be valid law. The latter ceases to be valid law. That is, the act of the legislature, if it is in conflict with the Constitution, it ceases to be invalid because Constitution is supreme. Then the fifth premise, sorry, I'll go to the next. The legislature is limited by the Constitution. Unlike in England, where so far the court has considered that the parliament is supreme, and not only supreme, its powers are unlimited. No court can inquire. This is the legal principle which the British court has enunciated, which now they're planning to. There is a debate outside the judiciary. Why should it not be said that it is subject to certain conditions? But that is separate. In United States of America, in Madison case, they came to the conclusion that the legislature is limited by the Constitution because the legislature is created by the Constitution. That's how logically it was deduced. Then next is, if the law is not valid, then it lacks binding force. So if one of the law, that is the law made by the legislature, if it is in conflict with the law, if it is a conflict with the Constitution, a provision of the Constitution, then the law made by the legislature is not valid. And if it is not valid, it is the duty of the judiciary not to enforce such a law. So this is how, in Madison case, by logical deduction, logical legal deduction, the US Supreme Court asserted the power to rule against the validity of laws made by the Congress or the legislature. Over a period of time, the legal logic has found its acceptance. After all, you all know that Justice Holmes said, law is not simply logic, it is an experience. What was ruled in the Madison case over a period of last 150 years or more, it has come to be accepted by the people as an instrument necessary for protecting the rights of individuals and enforcing the legality in the government, or to experience government which sticks to rule of law. It is recognized as a counter-majoritarian instrument to protect the rights of individuals and minorities. That is how politically, in a political theory, where many political theorists find it difficult to digest judicial review as a power vested in the court to validate the laws made by the people in the Supreme Legislature, have come to more or less accept and live with power of judicial review. When this is the position, when this is the accepted position, in 1950, when India framed the Constitution of India was framed by Constituent Assembly, which got power under the Indian Independence Act, transferred by the British Parliament into the legislature, that is the Constituent Assembly, to frame the Constitution of India and to govern itself as an independent nation. And this act we call popularly as Grant of Independence. In a legal term, it is Indian Independence Act 1947, passed by the British legislature. Besides, in India, there were hundreds of princely states which roughly occupied about 1/3 of the area which is a part of India now, including the Mysore state, Hyderabad state, Trivandrum or Kashmir or Bhopal. These princely states were earlier under the paramountcy of the British Crown. The British Crown eschewed his paramount power under Section 7(1) of the Indian Independence Act and let all the princes free to do what they like. And these princes, who had no legs to stand on their own, because as long as British were in power, their external sovereignty was guaranteed by the British, and they had no choice but to join the Union of India or Pakistan if it fell on that side of the border. So that's how the integration of India was brought in. All the princely states signed instrument of accession initially on 3 subjects. Later, they accepted the constitution. So the Constitution of India was framed by the Constituent Assembly. Its power to frame the constitution was derived from 2 sources. One was the sovereignty transferred by the British Parliament. Second, the power surrendered by the princes in India. But the constitution opens with the word "we the people," because symbolically, the representatives of the people who enacted the constitution were representing the people. And in that broader sense, as if the whole India assembled at Delhi and enacted the Constitution of India. That's why we start with "we the people of India." Laying apart this, coming to the topic, the Constitution of India, which was modeled on the British unwritten Constitution and the written Constitution of the United States of America, decided to confer power on the Supreme Court and the High Courts to exercise power of judicial review in the form of issuance of writs to invalidate the illegal actions of the public authorities, which includes governments or any statutory bodies or the agencies of the government, and the legislature, which includes state legislature and the parliament. So vast power, very important power, is conferred on both Supreme Court and the High Courts. These courts, because of the conferment of such an important power, which is not conferred in other courts, are called courts of superior jurisdiction or court of records, because they have been on recognition as a court of record. They have the power to punish for the contempt. That is, if somebody disobeys their order, the writ, their direction, they have an inherent power to punish the person for contempt. They don't require Contempt of Court Act. Contempt of Court Act is only supplemental to these courts of superior jurisdiction. So these courts of superior jurisdiction, which have the power to punish anyone for the contempt, to have its order implemented, have the power to issue writs if the public authority or the legislature has acted inconsistent with the legal or fundamental rights. The only difference between the Supreme Court and the High Court in respect of judicial review is Supreme Court is limited to the enforcement of fundamental right. If you open Article 32, Clause 1, it states the Supreme Court is vested the power to enforce the fundamental rights. Then it says, for the purpose of enforcement of the fundamental rights guaranteed under Clause 1 of Article 32, the court will have the power to issue writs in the nature of mandamus, certiorari, etc. When it comes to High Court, it is not limited to the enforcement of fundamental right. It has a broader jurisdiction. It can enforce any legal right if that legal right is violated by a public authority, government, or agency of the state. If it is traced to the public authority, the court can exercise its writ powers, its power of judicial review, as we call in the modern sense. Otherwise, we all call it as a writ jurisdiction or writ powers. Exercise the power of judicial review and invalidate the action by declaration then quash it, then issue a consequential order, which could be in the nature of writ of mandamus, it could be in the nature of writ of certiorari, it could be in the nature of writ of prohibition. The difference between these three writs is historic, but still it is relevant. What do you mean by writ of mandamus? Writ of mandamus is basically a writ issued by the court after it comes to a conclusion that government or a public authority has wrongfully acted and the wrong has to be undone, and consequently the authority should be directed to take a fresh decision, or in rare cases decide as court directs. For instance, in a case relating to a grant of a permit or license, you take into any act, I'm not specifying, broadly I say grant of license, permits. If somebody has been denied a license or a permit, he goes to a court challenging the denial as illegal, as violative of the procedure prescribed, or he was not heard, or it is outside the powers of the legislature, whatever it is. If the court finds that, not outside the power of legislature, that is a different case. If the court finds that the act of the public authority is illegal because a particular procedure was not followed, a prejudice has been caused, then it will declare it as illegal, quash it, then direct the government or authority to take a fresh decision in accordance with law. Sometimes the court feels that the authority has been repeatedly dragging its feet. The court has extraordinary power of directing, you now issue a license or a permit. So that is how the writ of mandamus is exercised. Then you have the writ of certiorari, writ of prohibition. If a quasi-judicial body acts outside its jurisdiction, the decision is quashed like land tribunal, then a writ of certiorari is issued, directing the authority to take a fresh decision in accordance with law. Suppose an authority has acted against a person, though it has no powers at all, is completely outside its jurisdiction, then writ of prohibition is issued, directing the authority not to act, stop it. So this is how it is done. Now, broadly, this writ power of judicial review, was exercised in the first 4 decades, not 3 decades, you can say, from 1950 to 1980, strictly based on the principle of legality. The courts were stiff-necked, hard-nosed. First question they would ask is, who are you? What's your interest? What is your locus to challenge? They didn't bother whether government acted illegally or government acted outside the law. First question is, who are you? What is your interest? Why you have come to the court? First, we satisfy that. Then only we look into the legality of the action of the government. So locus standi was a very important threshold requirement to be satisfied before invoking the power of judicial review or writ under 226 or 32. There are several other self-imposed restrictions, though Article 32, 226 do not say, or 227 do not say anything with regard to the, or any restriction it imposes. The power granted to the courts are plenary powers. But since it's a discretionary remedy, the courts have imposed certain restrictions upon themselves. And these restrictions are in the nature of requirement of a standing, ripeness of the dispute. You can't just come whenever you like. There has to be ripeness. There has to be demand and denial. There should not be any latches. So all these various self-imposed restrictions are there. So court functioned in the first 3 decades. The writ courts or courts of superior jurisdiction, which exercise judicial power as hard-nosed court, stiff-necked. They would not look into anything which did not strictly fit into the legality or doctrine of ultra vires. If it fits in, the courts were very bold enough, no doubt, to strike down. When they found that the constitutional amendment in 1967 in Golaknath case or later in 1973 were found to be unconstitutional in a sense, they violated the basic structure, the court invalidated. There was enough boldness, but the approach in those days was an approach of strict legality. We'll have to strictly conform to the legal logic. It proceeds from one axiom to another, and if it legally logical, the action was invalidated. They did not go into the equity aspects. They did not enter into other aspects. That is how the courts functioned till 1980. The change came after 1979 when Supreme Court in the Maneka Gandhi case went ahead to say that, in fact, it overruled its earlier decision in Gopalan's case, that the law made under Article 21 to take away the personal liberty or life of a citizen is not just a law, it has to be a law which meets the test of reasonableness. This becomes very important because Article 21, if you read, what does it mean? It means nothing. It means nothing because it says that you have a right to life and liberty and it cannot be denied except by procedure established by law. That means if a legislature makes a law, state legislature or a parliament, your liberty can be taken away, your life can be taken away. That's all it means. It is only a guarantee against the executive, that's all. But if there is a law made by the parliament or legislature, it can be taken away. That is how the courts read it in Gopalan case. But in Maneka Gandhi case, court said this amounts to a meaningless guarantee. At the most, it's a guarantee against the executive, which cannot act without a legislative support from the parliament in case of center or state legislature in case of states. The court went ahead and said, mere passing of a law is not sufficient. It has to be reasonable. So test of reasonableness was introduced as implied in Article 21 by reading it along with Article 19 and 14. By harmonious construction, the court was able to come to the conclusion that the law which the constitution makers meant in Article 21 is not a mere mechanical law, but a law which conforms to the sense of reason, that is reasonableness. So this completely changed the scope of protection granted to the citizens under Article 21. Any law which unreasonably interferes into the life and liberty became a subject of challenge. The next step came. What is the meaning of life? The meaning of life is not just a bare life. The court gave a very meaningful interpretation to the term life, and it included dignity, right to live, right to sustenance, variety of things which goes to make a life a meaningful life. So by this kind of interpretation, the court was able to conceive the host of socio-economic rights which India had agreed to enforce in India by signing the International Convention in 1965. It's called International Covenant on Economic, Social, and Cultural Rights. The socio-economic rights, right to health, right to food, right to education, All these rights are not expressly conceived in the Constitution. But once Maneka Gandhi opened the door, and once the meaning of life was expanded to mean a meaningful life, not a bare life, the court was able to, by interpretation, hold that right to health is a fundamental right, right to education is a fundamental right, right to food is a fundamental right, variety of things. Even the prisoners who were called condemned persons were recognized to have right to live with the dignity, and for that purpose, various things, various measures which the government used to implement against the prisoners were knocked out by the court. This is how the court moved into the activist phase in the post-1980. The activist phase of the Supreme Court and the High Courts in the post-1980 has different categories. One is enforcement of the rights of the prisoners, where right to dignity was recognized. Secondly, enforcement of probity in public life, transparency. The court recognized that elections to be conducted should be fair, and for that purpose, slew of directions are issued in various cases to bring probity in the electoral process. The court recognized that the administration which conducts administration may have the power, but the administration cannot act secretly. There is something called transparency. People have a right to information. The administration is bound to part to the information whenever people need it for their purpose. So the right to transparency became important. Then the environmental questions came. Earlier, the courts were recognizing only the personal rights. And I had said, court used to ask the first question, who are you? What is your locus standi to file this case? But once the environmental matters and these matters became actionable in the court because of the expansive meaning of Article 21, the court stopped asking, who are you? The locus standi question was liberalized. All that you have to show that you have some connection to the issue which you are trying to agitate. The courts, in fact, started acting suo motu also. You all know that public interest litigation can be filed today. That is because the rule of standing, which was strictly enforced before 1980, was relaxed. Today, means since 1980, I would say, last 4 decades, a person can file a writ petition in the High Court or in the Supreme Court, though he is not going to be the beneficiary, but he will say, I'm trying to enforce the rights of laborers who are in large numbers spread over throughout Karnataka or throughout India, who are not in a position to come to the court and seek justice. Therefore, on their behalf and as their representative, I am here. The court accepts such a plea. The court also accepts a plea that though I have no right over the environment, I do not own water, I do not own air, nor I have any rights in the forest, but still environment, these are the parts of environment which is necessary for sustaining my life. Therefore, I have an interest. The court accepted this interpretation and granted a standing to the individual or group of individuals to come and enforce their right to environment by challenging some wrongful action of the government. That's how we saw the judgments by the Supreme Court directing the government in series of cases in 90s. For example, the Delhi bus cases, the entire fleet of Delhi Transport Corporation, about 3,000 buses, had to be replaced. They're all run on gasoline, causing a lot of pollution in the city. They had to be replaced by buses run on the ordinary gas, which will not cause pollution. It was a great thing. The court took upon itself the task of enforcing the rights. And in this enforcement, as I already said, they didn't ask the question, who are you? Nor the court bothered to ask strictly whether it fits into the writ of mandamus, a writ of certiorari, a writ of prohibition. Court broadly said, we have the power to give directions once we find that the right of a citizen is violated. So that's how in a broad spirit, court started acting to enforce the rights of the public, which were earlier not subject of any enforcement because nobody had a direct interest in these things to justify a locus before the court. Then it comes to socio-economic rights, as I already said. The court started enforcing the socio-economic rights by expansive reading of right to life. But here, one important thing you must all know, that is, court made one important ruling. Right to life in Article 21 is not only a negative right, but a positive right. What is this negative and positive? A negative right means, for example, right to food. Right to freedom to eat a food means nothing. That means you eat your food if you have the food. If you don't have the food, you don't eat. So right to freedom to eat a food means nothing. All that it means is that if you are eating your food, government cannot come and interfere. So this is not sufficient. This is a negative right. Court said there has to be a positive right because international convention had made it very clear in Article 2.1 that the socio-economic rights are not negative rights or freedom, but they are claims against the state. If you're familiar with concept of rights, whenever you see rights you read about the rights in your statutes, there are 4 kinds of rights. Right to freedom, right to power, right to immunity, and the most important right to claim. The moment you have a right to claim something, somebody has a duty to satisfy that claim. So when right to food, right to health, right to water is read as a positive right under Article 21, it is read as a claim. Claim against whom? Against the public authority, that is the state. So the state came under an obligation to provide food to a person, shelter, health, all these kind of things. It became an obligation. But a question arose. What do you mean? Is it a duty of the court? Is the duty of the government to feed every person in the street? Is it a duty of the government to provide medicine to everyone in the country? Here, some restrictions are come. The courts, while enforcing socio-economic rights around the world, particularly the South African Constitution, which was the first constitution which expressly recognized socio-economic rights, itself says in section 27 that the right or a claim has to be realized progressively. At once, you cannot direct the government that please extend the right to health to every citizen by opening a hospital in every village in the country. It can't be. But certainly, there has to be a scheme. Government is accountable to come and say that we have a scheme. Under the scheme, it takes about 5 years or 10 years to progressively realize the right of the citizens. Same thing with regard to the drinking water. Same thing with regard to the shelter. That is how we see a lot of welfare measures being implemented in the country. And all these welfare measures, including right to education under Article 21A, are intended for progressive realization, because a duty is cast upon the state. And this duty is cast upon the state from where? It is from Article 21, because the courts read Article 21 as a right, which is a positive right, which cast upon the government an obligation to provide. It's not only a negative right where the government will just allow you to exercise your freedom, allow you to work, allow you to eat, but it is a right which can be claimed against the government. The only one right which we are not able to really claim as a claim is right to work. In 1990, if I remember, the opposition parties made a commitment to the public in their election that if we come to the power, we will make right to work a fundamental right. They came to power. U.P. Singh became the prime minister. Then this question came up in parliament very aggressively. When are you going to make this? Then government started consulting the experts, legal experts. Then it realized that if you make right to work a positive right, then the government will be under obligation to provide employment to everyone. It is not possible. So that's how right to work as a positive right, like it has been done on Article 21A, was deferred. But subsequently in 2008 or 9, or before that, Manrega came, though it's not a constitutional amendment, but act of the legislature, but it is intended to provide employment to all those who have no employment. It is not an employment of your choice, but something an employment so that a person can earn and eke out his livelihood. So this is how socio-economic rights are conceived under the Constitution, by giving an expansive meaning to Article 21. But the way to realize socio-economic rights depends upon the purse of the government. The purse of the government depends upon the legislature imposing the taxes and collecting the revenues, etc. Therefore, the realization of a right cannot be mandated like the courts mandate any other things. If it finds that somebody has violated the law, public authority, you issue a mandamus. Such kind of a inflexible mandamus cannot be issued, but the courts have taken a meaningful approach in trying to have these rights realized by framing a scheme, by framing the certain formulas. I've been able to get it implemented, but not fully, to some extent, no doubt. So this is how it is done. Now, the last category of activism is the courts make sometimes the law also. In Vikasa case, on the question of sexual harassment, the court found the present legal structure is very inadequate, or there is no legal structure at all. A lot of sexual harassment takes place in the workplaces. Therefore, this needs to be regulated. And after coming to the conclusion that the woman has a right against sexual harassment, and every citizen has a duty not to indulge in sexual harassment. In order to realize these rights meaningfully, the court said, until the legislature acts and makes a law, we issue directions, we frame norms, and these norms have to be adhered to. And if they have not adhered to, we will exercise our power of contempt and enforce them. So this is one area. In fact, it first started quite early, not only Visakha case. It was, I think, in 84 sometime when Justice Bhagwati framed the norms for regulating the adoption of children by the foreigners in Pandey case. That's how the court started. Then in Unnikrishnan case, the court by its judicial order framed a scheme for regulating the menace of the capitation fees and so forth. There are so many things, but these are the norms framed by the court in an area where the court finds there is no law, but the citizens have a fundamental right, or the any other, not citizens only, any person has a fundamental right under Article 21 or 14. And if such fundamental right is there, the court considers that it is its responsibility to give a legal framework for meaningful exercise of that right. Otherwise, the right guaranteed by the Constitution becomes a paper right, which is of no use. This is how the various ways of activist role of the court is being seen in the last 4 decades. As I said, first 3 decades, courts strictly enforced the rights, strictly acted under the doctrine of legality. It strictly invalidated the acts of the public authorities if they meet the test of doctrine of ultra-virus. In the second phase, post Maneka Gandhi, the right got expanded. The expansive meaning interpretation was given to Article 21, that right to life. The law made by the legislature has to be reasonable. But the most important is the right under Article 21, the right to life, is not only a negative right, it is not only a freedom, but it is a positive right, so that the state has an obligation to make that right realize. So citizen got a claim over the state to demand right to health, right to shelter, right to food, various things. But there is another principle that all these rights realization depends upon the purse of the state. Therefore, at once court cannot direct their realization. They have to be progressively realized. Minimum core principle is applied even in South Africa. So that kind of a principle is there. So today you see the courts playing very activist role in enforcing the fundamental rights, in enforcing the welfare measures for the poor. We have seen there are a lot of outcry. Recently, when the lockdown was ordered, people expected the court to intervene. Initially, court was hesitant because the court thought that it is judicially not manageable to do anything in this kind of a complete chaotic situation. But the court was strong. Later, it realized, then it intervened. Then it did issue certain meaningful directions to provide additional trades, to provide food and other things to the migrants who wanted to go back to their home and who thought the lockdown would be a long process and their stay in Delhi or Bombay or Calcutta, wherever they're staying, or in Bangalore, is not useful until their life comes back to normal, which may take days, months, or a year. It looks like it may take more time. Now, again, the court is faced with one more difficult issue. The crisis arising from the second wave of coronavirus. There has been some kind of a impression in the country that the government did not prepare itself. I'm not blaming anyone. It happens in the government. Whether somebody is blameworthy or somebody has done, that is a separate matter which the parliament may have to look at some time. That is a political process. But let us assume that we are not concerned with who has done what. But the fact is that the vaccines are not available. Beds are not available. Oxygen is not available. People are gasping for breath. And if one is not getting an oxygen, it's a serious matter. Therefore, court had to intervene. The High Court started intervening, passing directions. You saw how Delhi High Court literally cried for 2 weeks, asking the government to increase the supplies of oxygen. Karnataka High Court has also issued a direction very important direction. So these are the things going on, where in the most difficult area, where there are no really judicially manageable standards, the court is called upon to intervene, to protect the rights of the people. And this interference, of course, is being seen by the government as a interference into their executive functions. But that is the issue the court will have to decide. But broadly, one thing I would like to tell, public interest litigation is a safety wall. No government should oppose public interest litigation because the anger of the people is taken out in the public interest litigation. In fact, I always held that because of the increased public interest litigation, the political movement in the country is being sacrificed or killed, because the courts are acting as a safety wall by addressing the needs of the people. And as a result, the anger gets neutralized. And as a result, there is the political movement which should have been built against the government. I'm not saying present government, it could be on the previous government also. This has been going on for the last 30 years, is not built. This is one theory. But when it comes to a question of life, when there is immediate danger to the life, we cannot look into these political theories and all. The court ought to interfere. Court must come to the rescue. Court must do something. It cannot stand on the niceties. It cannot buy the argument that it lies within the domain of the legislature. That's all doesn't work. Courts, executive, both have to work together. It's not an adversarial litigation when it comes to the enforcement of the rights relating to the life in these trying circumstances. It is the duty of the government to cooperate with the court and make the court as a forum for adjudicating the cross claims of all the stakeholders and devise an equitable solution to the satisfaction of all and to the satisfaction of the judicial wisdom by incorporating the principles of equity. So this is how the court is expected to handle, and I'm sure they will handle it in the future. So friends, on the question of changing compass of judicial review under Article 226, 227 and 32, I just forgot to tell you 227. 227 is nothing but what is there in 226 itself. There is writ of certiorari. Instead of filing a writ of certiorari, you can file a writ, you can file an application under 227 questioning the legality of the decision of the tribunal. But it can also be filed a writ of certiorari under 226. That's the only difference. That's why most of the petitions are called 226 and 227 read together. That's how they are filed in the high courts, as I know, as I've seen. So this is broadly the thing. The changing compass of the judiciary is, the changing compass of the judicial review is, the judicial review itself is not a static instrument. It has to change according to the social pressures. Initially, the courts considered adhering to the strict legality is the best guarantee against the government. But subsequently, they found that's not sufficient. There are problems with the government, the governance. The people demands are increasing. People are asking for more rights. Consciousness has come into the public. And if the rights of the people go unaddressed, there will be a social revolt. Therefore, it became necessary for the court to expand its role, shed its inhibitions, give up its self-imposed limitations like ripeness, demand, and this locus standi, latches. All these things were given up, and the court became more receptive to the demands of the people and assumed the activist role. In assuming the activist role, it has, of course, trenched upon the powers of the legislature. It is making laws, but court is careful. The charge is not correct that court is making the law. It is making the law with the express rider that their directions or their legal regime conceived, like in Vishaka or in Unikrishnan case or any other case, is subject to the law which ultimately the competent legislature makes. So until the legislature acts, until there is a vacuum, the court fills up the gap by making the regulations, provided they are connected to the enforcement of fundamental right, not otherwise. So this is how the court has expanded its role. The compass of judicial review has changed from one of a stick neck court to the one a progressive court after 1980. So we have moved long enough, some stiff neck to the liberal court. But as the demands of people increase, as the rights of people increase, as the consciousness changes, there is nothing like a cap. The court will have to redefine itself and adjust itself to enforce the new wishes, aspirations of the people. Thank you very much. I hope you all enjoyed. And if you have any questions, certainly I would like to answer the questions.
Thank you, sir. And rightly so, to take the entire journey, even if we take from 1950 onwards, when we say that
the
new constitution came into being, to bring that entire this thing in a capsule of running around in 90 minutes itself shows that we were approximately. So your camera has shifted. Yeah.
Okay.
Approximately we were giving approximately 1.5 minutes to each year of the after the Constitution of India, and to bring that entire this thing, it shows the volume of knowledge. The way you develop from A.K. Gopalan, then Maneka Gandhi, Vishakha's judgment, and P.K. Unikrishnan, everything to be summed up from 226, 227, and this thing. But yes, you are rightly said. I remember that when we joined the profession in the early 90s, lot of debates used to be as to whether it is in Article 12 or not. There used to be a lot of litigation whether it would fall within the contours of Article 12 or not. Now I've seen that there's hardly any debate on this. Very rarely a case comes wherein it says it's not a state within this. Of late, only one I found against this IBBA, which says it is not a state, it's a society, therefore it's not performing the public duty as such. But yes, and then you took us back to all what are the rights vis-a-vis duties. And it was actually one of the mesmerizing sessions, and we have actually gained with that. And one of the platforms we have received one question.
Yeah.
If a writ of mandamus is allowed, and after that for same subject matter regarding remaining people again is filed with the same period, but means government changed that rule. What is the remedy for the petitioners? No, it says has filed the same, but meantime government has changed that rule. What is the remedy for the petitioners and what the court can give directions?
No, I didn't get the question. What is the point?
I will sum up in my own way. He says a writ petition is allowed for particular employees.
Okay.
Now, meanwhile, when the other persons have filed the writ petition, the government changes that particular rule.
Yeah, I get your point. Once the writ petition is allowed, directing government to grant certain pay scale. I'll just give an example, right? That they find that court says on interpretation, you are entitled to a pay scale of 32,000 rupees, right? Issues a mandamus to grant. Then the government, by its rule-making power under Article 309, changes the law and says, we clarify that this category of persons are not entitled to this case. So interpretation by the court is overruled by the rule-making power of the government. There is delegated legislation, or by the legislature by passing the law. Then what happens to that? This is a very interesting, because a lot of cases of this nature have come. There are also questions like somebody's building, high-rise building is demolished on a ground that you are entitled to construct only 12 floors, but you have constructed 14 floors. So 2 floors are to be chopped off. After the court issues a direction, the government changes the law with retrospective effect and says you can go up to 14 or 15 floors. Then what happens to the mandamus issued already for chopping off 2 floors? So these are the questions which have important bearing on the public law, on the judicial power. If you ask me, my view is this, that if subsequently law changes and if the law is valid, the validity of law has to be tested on fundamental rights violation, where the legislature has the competence to make the law. And if no fundamental right is violated, then the subsequent law is valid. The mandamus issued by the court gets neutralized. It is not enforceable. It has happened in the tax matters. It was very regular, in fact, earlier. The court would interpret and say that particular item is not taxable. Then the legislature would pass the law clarifying that it is taxable with retrospective effect. That is called validating legislation. So what was termed as illegal by the court was validated by the legislature. The court upheld such laws with a rider after checking that the validating legislation should be within the competence of the legislature and it should not violate any fundamental right. So if your claim is founded on a fundamental right, then legislature cannot change. And if it changes, the court will again rule in your favor. But if it is not a fundamental right, if it is just a legal right, then the legislature is competent to change that right. And if it changes, the basis of the mandamus disappears, then gets neutralized.
Two things I would like to add. Probably he says, now another situation would arise is that those persons win and appeal to the Supreme Court. Then, according to me, the law would be that intercede those two parties, the decision would be final.
That is a separate question.
Yeah.
If intercept judgment is rendered by the court, okay, we are talking about the writ jurisdiction, but in this jurisdiction also sometimes intercept judgment comes. If the intercept judgment is the inter partes judgment, right, then that inter partes judgment is binding. Okay, it cannot be overruled by the legislature. If the legislature interferes with the private rights, it is illegal. But still, this is a gray area. I'm not sure what happened because in the famous case in America, that is the case relating to the bridge case, they made a distinction. If there is a judgment crystallizing the private rights, the legislature subsequently cannot take away those private rights. If there is a judgment on public rights, then they can take away. The Supreme Court of India in Patak case, that was relating to in a Patak case and later in Nachani case also, said once a right has been crystallized into a judgment, it cannot be taken away subsequently by the legislature. But this area is still a gray area because the courts have indeed taken a view. And in fact, one of the cases which I appeared, Mullaperiyar Dam case, we couldn't succeed on the same point. Earlier, the legislature had fixed the reservoir level as 142 plus it can go up to the 145, they said, Tamil Nadu. Kerala passed a law saying that it cannot go beyond 136. Then I was appearing for Kerala. We tried to defend it, saying that it's the independent act of the legislature. It has passed the law. You cannot say that it violates the judicial verdict. But the court said it does impinge upon the judicial power. It cannot be done. This area is a little gray area. There are a lot of judgments. In fact, Nariman judgment is there one. Bill of attainder he refers to. This area is a little gray.
Yeah, I'm sorry.
The US.
No. In fact, I was just checking out of Facebook and suddenly the voice popped up. I was thinking as to whether any question has come or not.
Okay.
Yeah.
See, broadly, there is also an argument that all that the court enforces by issuing direction is the legal right. Who creates legal rights? Legislature. Legislature can change the legal right. So if they change the legal right, the basis of judgment goes. Therefore, the judgment is not enforceable. This is a simple argument being made. The distinction made by the US Supreme Court was public and private rights. Without that distinction, Supreme Court in India, in Patak case and Nashane case, they said that once a right has been crystallized into judgment, it cannot be taken away. Then subsequently said, well, it cannot be taken away in respect of those people, but general law, if it is, it can. It's really a gray area which needs to be one day addressed by the court in a very comprehensive manner. In service matter, it is very common, or in tax matter. As you win the case, the government will change the law. It is happening.
In service matter, the maximum things are, let's assume the government has appointed a lot of people. Then they do come out with an ordinance. Let's assume those elections have been quashed. They sometimes do try to protect the judgment of the state of Punjab versus Bhupinder Singh, and then
correct.
Huda's case, wherein they said that how it has to be protected, and then there was a judgment where he's saying of similar situated. At least in our High Court, there's a division bench judgment. Supreme Court also says that similarly situated person should be granted benefit of its own rather than forcing.
No, that is a difference.
That's a difference. He's trying to say nullifying. He's trying to say nullifying. Otherwise, I'm saying.
Yeah. But otherwise, similarly situated people will get. Nullification is a serious issue because you have been granted something and subsequently legislature passes the law to the contrary and say the law is not this, as court said, it is like this.
Then again, another debate which arises is whether it can be prospective or retrospective, whether it could negate that judgment. Like you rightly said that.
When the legislature passes the law subsequently, it is always passes with a clause for being made retrospective. Right. So from the date, whatever date they set up, they'll pass. So if it becomes retrospective, that means this judgment, which the court proceeded on the assumption that law is X, is not correct. The law is not X anymore. Yeah. This is how the difficulty comes. Now it has happened in the Videocon case, famous case. The Supreme Court ruled that government is not entitled to tax. The legislature amended the law, the parliament, and they said that it can. And thereafter the demand notice was sent. And again, it has been challenged pending in the court, but that is a serious matter. They won the case, but subsequently law was amended.
Yeah, because it was running into crores. Mangmesh, when direction is given under Articles 227, 226 or 32, but the authority does not follow, then what is the remedy?
Well, that is the contempt will follow. If authority does not follow the orders issued by the court, then you can haul up the concerned person who has not implemented the order, or a minister who has come in the way of implementation of the order, and charge them for the contempt. The court can certainly initiate action and impose whatever punishment they impose, then direct the government to grant or implement the judgment as they had directed.
So this is by Dr. Srinivas. Under which article of the Constitution specifically confers the power of the judicial review on higher judiciary?
222, 226, 227 and 32. Writ jurisdiction. Judicial review is the writ jurisdiction.
So we don't have any questions as such. Thank you, friends, for connecting with us. And as we always say, that kindly like, share, and subscribe the channel of Beyond Law CLC to have the previous sessions. And if you follow us on the Instagram and follow Facebook, you will come to know which sessions are coming forth. And as the question was posed to Mr. Mohan Katarki, to the effect, what is the effect if the judgment is not followed? I can say fortuitously, once we are talking about the judicial compass, which has traversed through the journey of around 77 years, if we count from 1947 onwards, and how the contempt powers will be coming there. Fortuitously, tomorrow's session would be on Articles 129, 215, read with Constitution of India by Mr. Asim Pandya, a senior advocate from Gujarat High Court. He's a former president of the Gujarat Bar Association, coupled with the fact that he has already written a book on Contempt of Court Act. So do join us tomorrow at 5 p.m. Yes, sir.
Because my name is Mohan Katarki.
I stand corrected.
I think you're not able to pronounce it.
This was I was talking to Trikram as well as Mr. Basraja. I said the same word, I will just give an example. We wrote Justice Hari A. Prasad. Then Baswaraja told me that the Prasad out in the north and the Prasad spelling in down south will never have the H there.
No, in
So these are the
Karnataka and
things-
Maharashtra, in Karnataka and Maharashtra, Katarki is pronounced. In North India, they call it Katarki. It's okay.
So that's what I'm saying. Sometimes the entire word and the pronunciation keeps changing. So we are thank you to sir for sharing his knowledge, and it was a treat for the mind to absorb all this session in the way the time flew, and especially during these testing times. We can only enjoy it by staying home and having the knowledge, though on virtual, but actually it gets deep into the mind as well as the heart. Thank you, sir.
Thank you.
Thank you.